other factors surrounding sexual criminality. This is in the Mazimure case. What the second respondents are merely supposed to do is to accept the notification, receive the notification, to then factor in and say that the second respondents received a letter from the president of the political party 2 days earlier, and then received a letter from the Secretary General of the party that would in effect be carrying out an inquiry, and the applicants would not be performing their functions in section 139 1K. Now the Constitutional Court also in Mazimure and in Tasa cases has clearly stressed how section 129 1K must be interpreted. Now my learned friends, Advocate Ngogo, states that the speaker was supposed to act and infuse other constitutional provisions like section 68 of the Constitution, that is the right to administrative justice. And in their papers, they also allege that the right to be heard was not upheld in carrying out their functions in terms of section 129. Now the law is clear. Section 129 1K is a complete provision. It is not subservient to other constitutional provisions. It is not a slave of the Bill of Rights. It must be understood in its literal sense and grammatical sense. And the learned Chief Justice, the Honorable Lukmalapa, correctly stated that section 129 must be interpreted that way. And a party cannot import or infuse other constitutional provisions. So to say the speaker was supposed to call the parties and carry out an inquiry, and that there is sort of a legitimate expectation to be consulted before effecting section 129 is unlawful. Now I'll move on to my last point.
How many did you say there?
Just 3 points.
You exceeded that.
The second point was quite broad because since we are representing the second respondent, we had to.
No, I'm not stopping you. Why?
Now the last point is whether this court can or should interdict a constitutional process like the one in section 129 1K. All the applicants have made some amendments to the relief they seek, but it is evident that the relief in HC 6684 of 23 was not amended, and that is in paragraph 6 of the draft order, that respondents and all those claiming or acting through them on their behalf be and hereby interdicted from interfering with the applicant's duties as members of parliament. That was not amended, so I assume it is still the relief that the applicant has still.
Answer, let's clarify that.
That is the exact paragraph that has been amended.
Yeah, because I thought the draft orders in both methods were similar.
They were quite different. They were similar, but there were some paragraphs that were
That's the concept, that one is equally applicable.
So my last point, though, it still stands, that whether this court can or should interdict a constitutional process like in section 129 1K. Now, there's a time-held doctrine in this jurisdiction that it is not permissible for a court to interdict the lawful exercise of powers conferred by statute. Now, what the applicants are seeking is amounts to interdicting or stopping the speaker from disturbing the applicants when they carry out their duties in Parliament. In fact, it almost acts like a cover for future.
But they drawn that. They say it only relates to the first respondent.
Very well, but it only relates to the first respondents. But paragraph 7 in HC 6684 of 23 was also not amended, which is also similar relief that amounts to interdicting the second respondent from recalling the applicants.
What does it say?
It says that that the second respondent hereby he and hereby participate in restraint from acting on any correspondence purporting to be on behalf of the Citizens Coalition for Change other than the party's designated official for that purpose being its leader. Now it amounts to interdicting the lawful exercise of powers in terms of section 129(1). Now as I already stated, it is not permissible for a court to interdict the lawful exercise of powers conferred by statutes, especially a constitutional duty. This was correctly outlined by Patel J.A. as he then was in the Judicial Service Commission case, which is in paragraph 34 of my res of arguments. Now, the relief that the applicants are seeking is too broad, it's too general, it's too ambiguous. Because it amounts to placing a caveat that in future the applicants are now immune to section 129(1)(k) in future and in present. Now this is clearly unlawful, as this also amounts to the courts violating the doctrine of separation of powers. The court will be overstepping its bounds by entering into the sphere of Parliament and stating that in terms of section 129, the second respondents cannot act in relation to the applicants. We also submit that with this, the relief that is being sought cannot be granted. Now, before I conclude, I would just want to state that, my Lord, it is important for this court to censor the applicants. Some of the language that was used by the applicants to scandalize the speaker, with respect, is unnecessary. The applicants allege that the speaker is in some kind of connivance with the party they call ZANU-PF. They call it a ZANU-PF hatchet job. And that the speaker is colluding with this political party. And they blame the speaker for their recall. With respect, that language was not necessary. And to scandalize the good name of the speaker, it's not really necessary. And we pray for the court to visit the applicant with a court order for scandalizing the speaker, the office of the speaker, and the president of the Senate, the members of parliament or former members of parliament was really not necessary. Before I conclude, may I just get some instructions from the other legal practitioners? This will be our submission.
Thank you. Thank you very much. Mr. Kanigwa.
Thank you, Lord. Lord, my, yeah, it's like the no relief that is sought against the third respondent anymore. And in view of that position, the third respondent will elect to abide by the decision of the court in this matter. I will end here.
Thank you.
Yes, my lord. My lord, I'm indebted to my colleague for the second respondent that has brought to my attention that perhaps my attempt to amend the draft order was not as thorough as I intended it. The intention was in effect to clarify that relief is being sought against the first respondent, and anything against the second and third respondent is being abandoned. That includes paragraph 7 of the draft order, which relates to the second respondent. My sincere apologies, my lord. This was addressed in the answering affidavit, and this is the intention of the applicant.
So you are withdrawing everything against the second and third respondent from your draft order.
Indeed. In respect of the substantive relief, even as will appear from the affidavit, it is the first respondent that is being sued on this application, my lord. And that brings me to my response to the submission by my colleague. My lord, I wish to take the court back to the draft order to clarify and solidify the relief that is being sought by the applicant. My colleagues for the first and second respondent have come up in arms in defense of the second respondent, and I wish to simply highlight that it is not the speaker who is being sued, and there is no relief being sought against the speaker. The question of the speaker's role and duty to uphold the Constitution and a certain standard of behavior.
They have the right to say that because your draft order is replete with allegations, rather orders that you want against the government.
Indeed, I do accept.
And now that we have said, they categorically said we are withdrawing every paragraph that seeks an order against the presiding officer of Parliament, then we must be good.
Indeed, my lord. I do acknowledge that adjournments were made with regard to the speaker. However, my submission is that the draft order itself seeks relief against the first respondent, and in particular to invalidate the letter that was written by the first respondent. That letter by the first respondent, purporting to act on behalf of the political party, is with respect the only issue before this honorable court. As per my earlier submissions, my lord, while the role of the speaker and the consequence of his actions may be an interesting subject for debate, it is not the case that the applicant has brought before this court. And interestingly, the first respondent.
So you were doing it for interest sake.
My lord, I do not abandon the submission that once the speaker has taken up a constitutional role, he is bound by the constitutional principles and is ought to act as an administrative authority that applies his mind. However, as I said in my earlier submissions, once that letter to the third respondent had been written by the speaker, that aspect of this matter is neither here nor there. And the heart of the matter.
You want to respond to his point. He says section 129, 1K of the Constitution is a complete book on its own.
Indeed.
And we cannot seek to import other sections of the Constitution into it.
Indeed, my lord, we do not seek to import other sections of the Constitution to it.
You intended to import section 168, 68,
To
the
68.
administrative justice issues.
That is with regard to the role of the Speaker. However, as I am trying to do in these submissions is to bring us back to what the applicant is actually speaking. And the applicant's assertion is that section 129K of the Constitution has not been properly invoked. And that means the role of the Speaker does not come into play in this question. The first respondent simply has one case to answer. Where is your mandate or authority to speak on behalf of the political party? And where is your evidence that the applicants have ceased to be members of the sector? That is all that this application seeks to address. That is what it is about. And unfortunately, the first respondent submissions completely miss that aspect. Even in the papers, there is no evidence of any authority. There is no evidence of any cessation of membership. That is the first part of section 129K. Before we start to speak of the validity or otherwise of the Speaker's actions, we speak of the validity of the first respondent's letter. This is what the applicants seek to interdict. This is what the applicants are asserting is an act of fraud. Once that allegation has been made against the first respondent, the onus shifts on him to say, this is what based my actions. What is interesting, my lord, about the first respondent's submission is he's the first one to cry and say, call the political party to come and speak for itself. He says the political party must come and speak for itself. That is the exact concession that I'm speaking to my lord. He has accepted that he does not speak for the political party. He is on a polygon of his own to remedy issues of his own. But the position of the political party with regard to the applicant is common cause and undisputed in these proceedings. That the applicants were elected as members of parliament and of the Senate respectively under the ticket of the political party is not disputed. The letter from the president of said political party, who has been acknowledged in the submissions of both the first and second respondents, is not disputed either. My colleagues wish to hammer on the issues that have already been resolved by this court. It is accepted that the Speaker has no role to adjudicate in the internal affairs of the political party. Those internal affairs are being brought before this honorable court. And the applicants, as the affected members of these purported reports, are saying we do not know the first respondent, and he has no authority to speak for us. Our membership has not ceased, and section 129K of the Constitution has not in fact been invoked. That is the question before the court, and that is what the entire draft order speaks to, the validity of that particular letter. And as I submitted, my lord, and I do not wish to overly admit the authority on this point, once that allegation has been made, the onus shifts on the first respondent to prove his mandate and to prove the so-called cessation of membership, which is wholly denied by the applicant. Once it is accepted that he cannot speak for the political party, once he has admitted that he is not the political party, and in fact has said, where is the political party? He accepts that it is not myself. The inquiry need not go any further than that point, as it is his letter that is being appealed. And to speak to the issue on jurisdiction, this is an application for a declarator and an interdict against the first respondent. The allegation is fraud. With respect, annexures ST1 and ST2 relied on by the first respondent are equally fraudulent, and in fact do not speak to any mandate relating to section 129K of the Constitution. It is denied that he is a member of the political party, and it is denied that he has been mandated to act for the political party in any way, shape, or form. ST1.
He did so in response to the annexures that you have also filed. You filed an annex in which sure whether it was PP1 or what, but it's one of your annexes in your application. Where you then attach a document that was authorizing some people to countersign the nomination of candidates in the election. That doesn't speak to 129K, does it?
Indeed, however, that document
And that's when the first respondent also filed a document countering that attachment that you have made. But you are right, both those documents are totally immaterial because they don't speak to 129K.
Indeed, my lord. However, the important acceptance by the first respondent is that those documents were authored by the leader of the political party concerned. And he accepts that he does not speak for the political party itself. I do agree with his lordship that those documents are not what speaks to the nub of this case. In those documents, it's sought to dispute the membership or otherwise of the first respondent, but it is admitted that even if the first respondent is a member of the party, and even if the first respondent was assigned to sign nomination papers for some members, he does not have the mandate to act for the party in terms of section 129K. That is the mere case that is being made by the applicant. And there is nothing that the first respondent has furnished to this court to
Like
to
I indicated
back up.
to you earlier on, the only issue that I want to clarify is who does it.
My lord, it is the appointed president of the political party who then wrote to the speaker.
So
on
your
the
point
floor.
is that the Triple C party spoke in this application through the letter that was written by.
Indeed, my lord.
Um,
Indeed, my lord. And the action emanates from the applicants themselves, because the applicants have no reason to sue the party. They're saying the party is not the one that expelled us. The party is not the one that has seized our membership in any way, shape, or form. They in fact have no relief against the party at all. They're saying that this is a stranger who has forged documents and is purporting to seize our membership, which membership, at least at the point of them being elected, is an issue of common course. And so this is why I submit respectfully, my lord, that once the first respondent claims that there's been a cessation of membership that nobody else knows about, it is up to him to prove his mandate to have seized such membership. And there's no such evidence that has been brought before the court. And accordingly, if we limit ourselves to the actual relief being sought against the first respondent, this is a very simple case, which in fact has been admitted by the first respondent. It's also admitted by the first respondent when we make the call to say, let's bring the political party. What does he do to distinguish himself and his actions from it? And this is why I say, my lord, that this case needs go no further than that particular aspect, because we cannot have section 129K invoked when the political party has not said anything to change the state of membership of its applicants. My lord, I believe this addresses the preliminary points, but out of the abundance of caution, I just wish to address the second respondent submission. I do understand where they were coming from in the need to defend the second respondent's position. And I wish to clarify that the office of the second respondent, it was never the intention of the applicant to disrespect the same. The paragraph referred to where there's an allegation of scandalizing the second respondent. I wish to clarify that this is fully directed at the first respondent. What this paragraph says is that the second respondent has turned a blind eye. And this relates to the submissions on the duty of the speaker, which I've accepted that do not actually extinguish the case that is before the court. And so for
did
that.
you assist in the drafting of the
No.
would you?
My lord, it is I must state it's a team effort which involves a
But you
variety
agree,
of.
counsel, that some of the language used today is completely unacceptable.
My lord, I can agree to the extent that it was unnecessary for the purposes of these proceedings. And I think it stems from perhaps passionate but misplaced passion in this case, which is why I have not sought to justify what appears, but simply to clarify that if there is any indignance, it is really directed towards the first respondent. And perhaps the applicants felt, whether correctly or not, that a constitutional office such as a speaker ought to also have maybe given due consideration to the two letters that were before him. However, as I've accepted in my earlier submission, the issue of the letter having been written before the letter by the leader of the political party came, it affords the speaker the benefit of the doubt. And again, it is neither here nor there in determining the question of whether or not section 129K was properly invoked.
Thank you, Councillor.
Indeed, my lord. With that, perhaps I feel it is appropriate to extend apologies to my colleagues as well as the respondents and to the court. Should any of the language have been intemperate for the purposes of the procedure. However, it stems simply from a cry from the applicants that their own rights should not be so easily altered by the actions of one
I
man.
thought you were extending an apology.
I will confine myself to the apology. My apologies. And then, my lord, those would be my submissions, both in response to the points in limine and rebuttals on the minutes.
Thank you.
Okay.
Mr. Willie, you still have the files for
Maybe they think you've forgotten me.
I'm
Easy to be forgotten.
actually this, I'm sorry,
Already engaged with you. My very friend, not the referee, submitted that we are alleging that Parliament failed to fulfill the constitutional obligation. Well, with respect, those are not our submissions. We have recourse to the relief that we are seeking. We are clearly seeking clerical and consequential relief arising from the first respondent's action. So much so that even if you were not inclined to grant relief against the second to third respondent, we will be quite happy with you granting an order as against the first respondent. Once the actions of the first respondent are declared unlawful, everything else falls away. That is my second submission relates to your most important question. Who does this record? Who should? Who did? The simple question, answer my left to that question is that the political party has advised the Speaker or the President of the cessation of members from the political party. But the point is made in our papers, my lord, that it is not the political party that did so. I need not belabor that. But what is also clear, my lord, from the papers that are before you, this has not been denied, is that the actions of the political party themselves are not complete without the actions of the Speaker and the President of the Senate complete the matter that is before you.
becomes important, my lord, and that is not being denied, that before the Speaker and the President of the Senate were two positions from the Part CCC, which were in direct contradiction, in direct conflict with each other. As if to suggest that there is one CCC which refers to the possibly the interim secretary general of America, which has the note of Canada. Let us wait before Speaker and the Senate. But on what basis did the Speaker or the President act on the letter by the first respondent? They could only have done so if they were making a decision in respect to what position they were before them, which, my lord, we submit was incorrect for them to do so. And in doing so, they were not acting in terms of section 129, 1K of the Constitution, which distinguishes, my lord, this matter from the Mazumure cases and the other cases where pronouncements were being made in respect to how you deal with a letter written to you in terms of section 129, 1K. So that is the point that we wish to emphasize. So the point, my lord, is that section 129, 1K was being misapplied by the Speaker and the President.
You detracted from the point that she made earlier on when responding to the question of jurisdiction. She said she's not worried about what the presiding officers then did. She's worried about what court is going to do, what they did, which is the letter that the applicant said it was fraudulent. But if you go back to challenging the actions of the presiding officers as they will not be compliant with section 129, you then fall squarely into the argument that Mr. O'Reilly is making, that you are alleging that Parliament failed to honor its obligation in terms of the Constitution, and therefore this court will not have jurisdiction to preside over this matter.
My apologies, my lord. I had already addressed in respect to the constitutional aspect that we are seeking a clarity as well as a perspective of the bill. But in respect to section 129, we are saying that that is not our argument. That is not the.
If it's not your argument, you don't make it, Mr. Mahara.
No, my concern, I want to be clear, my lord, that that section was not, it is not as if the Speaker and the President were acting in terms of section 129, because they are two conflicting positions before. I just wish to make that point, my lord, that the court must take notice that there were those two positions. It is not good. Well, in regard to the issue that the first respondent was also appointed to sign for paper, I think it was answered. My then friend says that we did not answer to that. We actually did. We filed a court application in which these colleagues were being challenged in respect of their action. So that's my lord is supposed to be read. So my lord, the rest of the issues I want to leave here on because I have nothing to say.
By any chance, that thing might
briefly make submissions on the promising linear. I will start off by saying that at the commencement, Humpty Dumpty was on the wall. Humpty Dumpty is no longer. My Lord, the case stands or falls on the founding affidavit. The founding affidavit makes a case against the Speaker or the President, as the case may be. We have raised in limine litis, and none of my learned friends have addressed the argument in our head of argument, that there is no causa against the first respondent. There being no causa against the first respondent on the founding affidavit, the withdrawal against the Speaker and the President is a withdrawal of the whole cause. My learned friends now agree with the argument I've put in our head of argument, that their cause should be something outside the present cause. It must be a separate action against the first respondent in separate proceedings. Because in the present case, as we state on that point in limine, they have not made a case, a causa against the first respondent, and they've admitted it now. But they go backwards and forwards. In one breath, they say we don't make an allegation against the Speaker. We just want the first respondent. He's our target. In the next breath, they say the Speaker was acting outside section 129(1)(k). They can't have both ways. Either they are for the Speaker did nothing wrong, and they are just going for the first respondent, or the Speaker did something wrong, and their founding affidavit is that the Speaker did something wrong, and their departure from the founding affidavit is a departure from their case. Their case ought therefore fail. Related to the causa issue, we made at length the submission that they rely on inadmissible hearsay. None of them is related to that. The letters by Chamisa, who is not before the court, ought to have been introduced through an affidavit by Chamisa. That has not been done. They are inadmissible hearsay. The rule against hearsay also applies to documents. They have not answered to that. That is in our heads of arguments. My Lord, in all the circumstances, therefore, Humpty Dumpty cannot be rescued, no amount of peppering and piecing together. We pray that the application be struck off, alternatively be dismissed with cause. Those will be our submissions, unless my Lord wishes us to present a
Thank you.
Just one authority, my Lord, which has come to mind. My Lord did ask about the distinction between the Speaker and Parliament. At page 11 of the cycle-style judgment in Tshabangu versus Parliament of Zimbabwe, that is dealt with, my Lord. Which is perhaps the reason why my learned friend, it's CCZ 2 of 20, Tshabangu and CCZ 2 of 2021. Yes,
It must be Tshabangu.
Tshabangu versus Parliament of the Republic of Zimbabwe, CCZ 2 of 2021. That's the judgment number.
2 of 21.
2 of 21.
Thank you, Council.
Which is why my learned friend then pulled off from that submission and said that we are not making any allegations against the Speaker and Parliament. We are making allegations against the President. It's good to go. Thank you, my Lord.
Once we respond to anything else, you raise it.
We have no further submissions.
Please,
That is
did somebody talk about the sitting of the nomination court?
Indeed, my Lord.
When is it?
Tuesday next week.
What's the date?
7th.
The 7th.
The 7th of November.
So it should be affected by the decision of the court in this matter.
Indeed, that's on the decision.
Thank you very much, everyone. The decision of the court is reserved, but it will certainly be out before the 7th.
All right.